Okay, can everyone out in the other room hear this? Turn it up. Can you hear out there?
That's the megaphone.
Okay.
Lucas has to.
I'll just stand in the middle and yell, I could do that.
When we did this. Space, we're gonna do all this. Yeah, that's right. Last call for the government.
Rough in there sometimes too.
That's the thing, you know, church is a little.
I think where she got that. Yeah. Yours, I have 5 years. Patients. I hope all your ducks in a row. On stage as well. Yes.
It does, you get away with it. People in motels and stuff. You know, that under.
Yeah. Fellow Virginia.
She, it's in a house.
I help all stuff like that.
Anyway. So, what's your name? I told her.
It all shows. Is that you, Gordon? Oh. You may know, yeah, he's beginning with, I need to. I don't know. Yes.
Okay. Could you even want to read some?
Rich, I was. That's right.
Thanks for coming to my birthday party.
You, somebody would come.
We forgot the present.
Oh, that's okay. Shut up. Yeah, seen you everywhere. Like a bad.
That's what he says.
That's right. I'm starting to see a pattern.
You're in a good row.
Sarah tell you I saw her?
Yeah, she was thrilled.
She looks great.
She's just amazing.
Well, you know, they're my new work. Yeah. Nice. I like the color. They're sexy.
Can you silence your cell phones? Right, please. And we'll be ready to start.
Yeah.
That's the order. I grew up in a small town.
Sorry. Need a little entertainment.
No.
Let me kill you anyway. See, not so
There's one more chair and somebody would like to.
Yes, 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 yes. My husband Jack. Nice to meet you. One more chair. I forgot her name.
We don't understand sign language, see?
Wow. Yeah.
Meeting to order, please. If everyone will stand for the pledge of allegiance.
Allegiance to the flag of the United States of America. One nation under God, indivisible, with liberty and justice for all.
Roll call, please, Captain. Chairman Patterson. Here. Mr. Winky.
Present.
Mr. Fulton.
Present.
Mr. Yago.
Present.
Mr. Lund.
Present.
Thank you. We have a quorum.
A couple of things I want to say. Typically at this time, we do recognition of visitors, but I have the list of everyone that's here. So I'm going to read through this list. If anyone doesn't hear their name, let us know, or I will be bringing this list back out into the other room so you can add your name to this list. And also know that there is a little bit of feedback that we're getting from in here. So when you're talking in the other room, we are getting a bit of feedback. So please try to keep your talking in the other room to a minimum. So I'm going to go through this list of recognition of visitors where I will state your name and your physical address. Ronald Frobel, 30 Galena Court. Rose Frobel, 30 Galena Court. Elizabeth Frobel, 30 Galena Court, Pamela Wolf, 80 East Calcite, Robert Wolf, 80 East Calcite, Travis Oshman, 509 Broadway, Nancy Pike, 280 Pyrite Circle, Joan Brodston, 5 East Calcite, Clay Mayor, sorry if I just said that wrong, 100 Granite, Barbara Gillespie, 10 Kryptonite, Maria Duran Shy, 65 East Calcite, Kit Shy, 65 East Calcite, Robert Veltri, 509 Howell, Lauren Dwyer, 585 Mineral, Connie Thompson, 570 Mineral, Jack Thompson, 570 Mineral, Michael Poisson, 205 Pyrite, Becky Poisson, 205 Pyrite, Betty and John Bowling, 300 Mineral, Jolie Epp, 330 Mineral, John Price, 60 West Calcite, Mark and Eva Middendorf, 160 Pyrite, Lloyd Smith, 30 Pyrite, John Caesar, 55 Granite, Hal and Agatha Shepherd, lot 32, Alice Henderson, 250 Pyrite, Lisa Walling, 20 Quartz, Jeff Wayand, 60 Quart, Charlene Potts, 535 Mineral, John Potts, 535 Mineral, Kevin Ferreira, 325 East Main and lot 14 in Shadow Ridge, Karen Berg, 60 Kryptonite, Barton Berg, 60 Kryptonite, Ray Holly, 35 Quartz, Charlie Ellison, 106 Bluff and 205 Mineral, Dan Johnson, 220 Pyrite, Kat Johnson, 220 Pyrite, and Jonna Hall, 65 Quartz. We have a Dave Vining on Zoom and a Melissa on Zoom. Before we move on to the next item, I just want to state really quick that since we've got so many Westcliff citizens here today, that we do have a Town of Westcliff board seat open, and anyone here can put their sit on on the board. And so I just want to put out there, since we have this number of people, citizens here, that it's a great thing to volunteer for your town. Okay. Approval of minutes. Has everyone had a chance to review the minutes?
Also move.
Motion's been made and second to approve the minutes. Any discussion?
Who seconded? Can you say that, please? Because
I seconded.
that way she can see it on the recording.
Okay.
Thank you.
Chuck Galgo seconded it.
Thank you.
Motion's made and second. Any discussion? All those in favor say aye.
Aye.
Opposed? Okay. And we have no old business. The new business, item A, is a public hearing of the possible rezoning of block 12 and 13 of Shadow Ridge. Let the record state that I will be recusing myself as I'm a property owner in Shadow Ridge, so I will leave the room at this point, and Chris will take over running the meeting. Yeah, you do. I'll go in the other room.
Negative record, setting in all.
State for the record, that John Van Dorn is stepping in for the citizen position.
That works.
Okay. So I think due to the number of people that we have here today, I would like to hear representatives from each side. One from the company who is the applicant, and then one from each of the opposed and, yes, ma'am.
Would you like me to set the podium so they can stand at it, so it's really?
Yeah, yeah, that'd be nice, thank you. So I first in line would be the applicant. Is the applicant here?
You want me to stand up?
Yes, he's deaf, by the way, and you will have interpreters.
Oh, okay.
So I'll stand right here. see. You all hear me okay? Okay, let me know if you need me to adjust.
Okay.
We're going in. Okay, so I'm glad that this public discourse is happening, just to show that America is still alive. I'm happy to know that some people have concerns with my proposal and preparations. I kind of want to step back for a second and just talk about the origins. I had the opportunity to buy this property. And it was there as a multifamily property. Through the broker, through the title company, through the developers, I was told and advised as an investment company that I could have that land or purchase that land. And 8 months later, I made plans to purchase it. And then I found out later that there was some conflicting information that wasn't included in the county level clerk's records about the multi-level or multifamily housing. So when I came in, there was a change for it to be a single family units. That was unexpected. I believe we would benefit, the town would benefit in several ways through this type of housing, multifamily housing, and the proceeding of this type of construction. And I know there are people who are concerned and they can speak for themselves, but I want to hear from you all if you have any concerns, and I'm happy to respond to those at this time.
What was his name, where it's from?
I'm Travis Oshman, and I'm from Pueblo, Colorado.
No problem. I'm ready for the proposition, Aaron.
Say again.
Ready for the proposition.
Ready for the proposition?
Yes, so, well, if it makes it easier, I can, I know there's a language barrier, but if it makes it easier, I can use what he has on his packet and read it all out to everybody here at the house.
What's wrong?
Yeah, that should be the proposal, so. I think it would be easier just due to the language barrier if you read it.
Yes. Okay, I'm going to go ahead and read off first from the municipal code. Declaration and standard of policy for the rezoning. It states here, rezoning shall be allowed if the applicant demonstrates by clear and convincing evidence that rezoning is necessary for one or the more following reasons. I sent that out to an email to Mr. Oshman. And the second reason was, states in the municipal code. 2, the area for which a rezoning request has changed or is changing to a degree that it is in the public interest to encourage a redevelopment of the area or a new approach to a development. He says, 2, I would believe, he says, I believe number 2 would be appropriate for our given circumstance. And if I'm talking too quick, let me know, guys. Let me know if you think I need to provide an explanation proposed to be using, let me know if I need to provide an additional information. And for the building plan, it is hard to tell. Okay, but that's it. Yep, he chose number 2. So he believes that the area for which that is rezoned is requested has changed or is changing to a degree that it is in the public's best interest to encourage redevelopment of the new area. And one of the papers he has, to facilitate development in alignment with the existing bylaws of the Shadow Ridge subdivision, which permit multifamily residence on lots 12 and 13. That this endeavor aims to enhance the housing stock within the town of West Cliff, hereby accommodating the anticipated expansion of local employment opportunities.
So to be clear, the existing bylaws of the PUD allow for multifamily
No, sir. Here on June 6, 2006, so it was multifamily before 2006. Mr. Gerald A. Seifert of Shadow Ridge Holdings LLC changed lots 7 through 9 and 12 and 13 from multifamily to single-family residences to amend the setbacks for these lots and to amend the setbacks. So it was multifamily before, they changed it to single family and amended the setbacks.
In the bylaws themselves, do they restrict multifamily or just no consideration whatsoever?
It had, in the bylaws, there again, there was multifamily, an amendment came up on 2006 to disclose those from multifamily to single family. So they've since been changed and approved by the town.
And no other lots are,
No other lots in Shadow Ridge.
You said in your testimony that when you purchased the property, you were led to believe by a realtor and a title company that it could be.
Title company and the city clerk.
And the city clerk here,
County clerk.
the county clerk or the city clerk?
County clerk, sorry.
The county clerk?
That was an interpreter error. The county clerk of Custer.
Well, this is the town of West Cliff and the county doesn't have anything to do with this. So they've obviously been zoned single family since 2006, correct?
Yes, sir.
So if you were misled, sir, it was by the county
Or by the title company.
or by the title company, either one.
I don't want to jump to conclusions and say misled. Everyone said that this appeared to be the current CCR and that was the available information at the time. I believe even in the town, obligations to go to official business order for Custer County. You're obligated to go for Custer County to file all of the business agreements and statements for the public in Custer County as well. Is that correct? Including West Cliff and their businesses.
Kathy?
So that should have been recorded at the county when that was done.
Agreed.
In 2006 should have been recorded?
Yes.
Okay,
Correct.
yes, sir.
Anything with CCR should be recorded in the county. If there was an agreement that this town was going to change that, it should have been recorded at the county level. And the county did give me the updated CCR, and that is what the paperwork clearly said, multifamily.
I got a question from
I
the,
have three questions now. First question is, when did you purchase these properties, Travis?
Can you ask him to state his name for the record?
Yes, my name is Mark Mittendorf. Mark Mittendorf. Yes.
The question is, when did you purchase? I think the first three properties I bought around August. And the second, the other properties were somewhere around November. 2023.
Two other questions. In 2006, when these properties were rezoned from multifamily to single family, was a public hearing held?
Yes, it was.
And what was the reasoning to rezone those at the time? Caleb gave us some reasoning for this rezoning. So I'm curious, what was the reasoning at that time?
It would have been, if I understood what Kayla was saying earlier, the developer of the PUD made those changes or requested those changes. I don't know if there was a reasoning given behind that, other than maybe just speculation here, but it might have just been a bit more financially solvent for him. Yes.
If you would just give me 2 seconds, I have the minutes up here from that board meeting on March 8, 2006, and in August. Let me look in April and March. Let me look for those if I can find a reason. Well, but you guys can continue on.
Excellent. Yes, Clay, can you hear us? Clay?
Yes, Mr. Mayor, I can hear you.
The gentleman is saying that, we should have to abide by the county's, ruling. And I explained that this is Westcliff and not the county. Did you hear that part of the discussion?
I did, sir. And I have to admit a little confusion on my part. Is the property located within the town or is it located outside of town?
It's in town.
And what did the county have to do with zoning town property? They can't zone town property. So I don't know what happened exactly.
I think what the claim is they didn't have record of the zoning change. Regardless, I don't think the claim is that they're making the change. It's just that was what the record was offered to the gentleman.
Oh, well, I mean, okay, so it doesn't really matter, I suppose, regarding who's responsible for the record. We're not responsible for county records.
Okay.
That said, I think the issue isn't to consider whose fault it is that it's not properly recorded. I think the issue is to determine whether or not you want to adopt and or deny the application. So I think, this is kind of a red herring, regardless of what initially was assumed or understood by the applicant regarding the county records is immaterial to the current status, which is it's zoned inappropriately for the use that the applicant wants to use it for. And so I would just skip ahead of all this and go to the application and see if the application and the rezoning makes sense, regardless of whether or not we're bound by county records or not, which we are not.
Thank you.
Yes, sir.
By the way, that was our town attorney. Sorry. No worries.
So I'd like to be clear exactly what is the request or what is the proposal? I mean, multifamily, we're looking at how many units, et cetera, et cetera.
6 units per lot.
Okay, fairly high density.
Excuse me.
Yes, ma'am.
I don't think it's high
My
density.
name is Nancy Pike. I wanted to know how many lots that he had purchased his company or the company associated with the company or whatever. How many lots were purchased in Shadow Ridge?
I'm happy to answer. A total of 9.
Okay, I have the minutes through the Board of Trustees here, June 6, 2006. It is titled Consideration of Request to Amend Shadow Ridge PUD to eliminate the requirements for sidewalks and to change the uses of lots 7 through 9, 12 and 13 from multifamily to single family residence. Mr. Fieldman said that he supports. Yes, ma'am. So for you guys, this is the original minutes that describe Mr. Fieldman and Mr. Cipher changing, this was reported to the town through a Board of Trustees meeting, changing from multifamily to single family. Okay, and it says, Mr. Fieldman said that he supports Jerry Seifert in his request to remove it off the plat. I think that this could create a nightmare. This is Mr. Fieldman talking. I think that this could create a nightmare in the future of all the homeowners. If all the homeowners could decide that they want sidewalks to come to town, I think if you decide that language should be the homeowner's responsibility. Mr. Rowe went on to ask something else. Paul Snyder, sidewalks. Jerry Seifert said that there's more convening, and I'm gonna go skip ahead. Jerry Seifert said that there have been lots sold, which he has letters signed from the owner stating that it is okay to change. So he's talking specifically on the changing from single family to multifamily. So Mr. Seifert went to the owners, got letters that says it's all right to change from multifamily to single family. Paul Snyder said that just in case, I think it would be okay to do. Mr. Rue said if we needed to modify the code, we need to have it in there, but modify it to what it truly is. Mr. Purnell asked, sorry, there's a lot here, so I'm just kind of skipping through. Mr. Purnell asked, does this fall under the same category of those that have already been purchased? Speaking of 12 and 13, Jerry Seifert said this one has already been sold and he would rather it be single family. Manager Fieldman said that if Jerry could get the letters from the owners stating that it is okay, that it would be good. Paul Snyder said there will have to be an ordinance to amend the ordinance. I talked to Ralph Hay and I told him you might want to change the setbacks also. Paul Snyder said the town needs to see the letters that the property owners have been signed off.
So if I may clarify, Caleb, it sounds like at least a couple or a few of the lots, it was requested by the owners that it be changed, and then they decided to change the rest of them and got the okay from the other owners.
Yes.
To get that?
Yeah, that's roughly the idea.
Okay.
So if that is the reasoning for your question.
That's the best reasoning I got out of that anyway.
Sorry, I was paragraphs and paragraphs, I was trying to.
Yeah, sure.
This is Travis. So 1 to 6, the agreement was for the change, or were they not changed for land use?
This has nothing to do with 1 through 6. This is 7 and 8, 7 through 9, and then 12 and 13.
Just out of curiosity, is that standard practice for this to come, like a change to come to the property code? And does that have to be filed with the county?
So this was recorded through the town board of trustees meeting as a rezoning. So what they did, just to clarify, was got permission from the property owners, asked the board, got a vote, and it got passed. And then it was amended. Kathy?
And I believe they recorded the change on the map.
Yes, the change is on the map. You asked about lots 2 through 6. Lots 2 through 6 are still
And
commercial.
did they validate with the owners that that was an agreed change?
Yes, they got letters from the owners for the change. I just read that in the minutes.
More than 66%.
More, so at the time, Jerry Seifert was a 67% owner. It was only owned by a few individuals that he needed the letters from.
Paul Snyder mentioned an ordinance. Do we give another, an ordinance in 2006 regarding this?
It would have had to been done by ordinance because it changed our map.
Yes.
Was our town attorney.
And so this CCR was not updated, or it was?
We record things at the county. We take them over, record, and the map was recorded.
Yes, this is the official file, Shadow Ridge PUD 2006 amendment. It says Mr. Purnell felt said he felt comfortable with doing that, getting the letters, and that we can pass an ordinance to that effect. The board agreed. I am seeing if I can find the exact ordinance here. This is the end of the page. You might have it in the file somewhere.
So you mentioned that in your opening statement, something about it was, rezoning was needed as because of a change in the environment or a change in the community. Am I mistaken about that?
From a legal standpoint, I think there isn't a need to rezone. Because being here, I was led to believe that hold on, sorry. That this was a necessary stage for various reasons. It appears that there is information conflicting regarding the space. And again, I'm not an attorney myself, and so I may be interpreting it incorrectly, but in plain language, that's what it appears, is that there's a discrepancy there. Does that make sense? I don't believe there's a need for rezoning because I believe that we are following the CCR.
Right, any input on this?
Could you repeat that, please?
I asked Clay for input.
Yeah, so here's the deal with CCRs and third-party agreements. The town and county has no obligation and or is to act as any sort of third-party enforcement official between CCRs, HOA bylaws, POA bylaws, community agreements. In fact, if there's as an example, if somebody wants to apply to build a house in the middle of a POA 40 feet tall, and the POA says you can't build houses over 20 feet tall, and it's plain as day that there would be violating the CCRs. If that person applied for a building permit from the town, and it otherwise complied, meaning we would allow a 40-foot building, then we could approve the building regardless of what the CCR say. We don't intervene or interject ourselves into private contract and private issues such as an applicant and CCRs. The only way the town would be involved in something like this is if we were a party to like a PUD agreement or development in which we had set boundaries and rules to, that would overlay our regular zoning. So unless there's a PUD that overrides these CCRs, or these are CCRs from a PUD in which we're a party to, then, that's between the applicant and the private, whoever is controlling those CCRs.
Okay, thank you. Any other questions from?
Clay, I didn't hear you on that. Could you kind of just said, I apologize. I didn't quite hear you well. This is Caleb, by the way.
Yeah, hey, Caleb. You need me to repeat the whole thing?
just the part after you said like POA before.
Well, I mean, the bottom line is unless the town is a party to the CCRs or some sort of PUD agreement that encapsulates the CCRs, we don't intervene or interject ourselves into private contracts. And so we don't enforce, nor do we abide by private contracts. If there's an applicant and they apply for, a building permit, we don't look at private CCRs to determine whether or not it meets those requirements. We only look at our own zoning law and building laws.
Okay, and I assume then that we are not a party to this particular CCR? Or any for that matter?
Well, I haven't seen the
How is that?
agreement, so I'm not sure. I would assume that's in the packet, which I'm pulling up right now and trying to look at.
Okay, one moment, Clay, it's debatable how.
Excuse me, say that again, I'm sorry.
And requesting a clarification from the applicant. He said it was debatable.
Regardless of whether the town is a party or not, I believe it's debatable because that is how this town facilitates information between the PUD, the original plans and the modifications. That's why I say it is debatable.
Well,
But
you know,
he didn't seek the information from the town, he sought information from the county. Is that incorrect?
I collected information from various places,
Including the town.
And if I may
the
add,
broker, the clerk, the title company. And I'm sure that this is,
Kathy,
that you guys have ability to deliver accurate information.
So we do have the recorded plat, correct, with those changes?
yes,
That was recorded at the county, correct?
correct, I wanted to speak to that. The declaration, covenants, conditions, and restrictions of Shadow Ridge subdivision reported 25th of January, 2005. Records of Custer County, Colorado, clerk and recorder with respect to real property situate in Custer County, Colorado. So the top of this document I have here does state it was recorded with Custer County, Colorado.
and ma'am, interpreter. Sorry, if you can speak up to that.
Are you having a hard time hearing me?
Yeah.
Okay, thank you.
I have a question. You said that was recorded in 2005?
January 25th, 2005.
But the meeting
Earlier
was
was
2006.
Remember, and
Yeah, I do understand that, and that's kind of,
recorded.
yeah, that's confusing. And even here, it says lot 7 through 109, which are to be of the following uses, single family dwellings. And then in 2006, they moved it from multifamily to single family. So I don't know why that's inconsistent. I do see here,
That's a county record, right?
yeah, that's a county
It's
record.
It's not the town.
Well,
This is the developer's record that they recorded.
And part of me, does the applicant have copies of the title work showing the claim?
Not with me right now, but I do, yes.
What title company was used?
I don't remember the name offhand.
Local?
We did it online. I'm not sure. It was a long time ago, a while ago.
Yes, are you asking,
I need to state your name again,
my name
please.
is Mark North, are you asking whether his title reflects that these properties are still multifamily?
I want to see that the title reflects the claims, yes.
If, if the title indicates that they are multifamily, what is the point of this effort? He put in to have them rezoned.
I understand, we're trying to learn that, sir.
Agreed. I feel like this meeting shouldn't have never happened. I'm just playing the part. I'm just going through the steps. I feel like I collected the information in advance.
Well, this meeting is happening because there is the other residents of the development are under the impression that nothing is zoned for multifamily in the area. So there's just a conflict of interests here. So the idea is
Can
to
I
iron
disagree
everything
with
out.
that? Because there are conflicting information between the town and the county. And it brings us to a place where I think that rezoning happened in the aftermath.
No, it didn't.
Well, it was originally zoned as multifamily, and then in 2006, it was rezoned to single-family housing, single family.
Yes, and
There's no, it's black and white.
and if I may, if he's going to make the claim that there's inconsistency and that the proof of the inconsistency should be shown.
I agree.
And it's not with the town, it would be an inconsistency with the county records,
Correct.
not the town records.
Thank you.
We don't manage the county records.
They don't manage ours.
And it would be either the county records or the title company. Now, the title company has access to our records, do they not?
The title company has access to our, yes.
Very good. So it's clear in our records at the town that this was rezoned single family in 2006. We've got that documentation. It was registered, we took our map over to the county and changed it when that happened in 2006, correct?
Yes, sir, I have the map right here.
So if the county didn't adopt it, didn't bother to change it, we can't be held accountable for that. I wouldn't think it would apply. I'm not the chairman.
John,
I'm looking at Chris. One thing I haven't heard, did we close the loop and actually pass the ordinance relative to the change in zoning that was requested by Mr. Seifert?
I do have here, agreement to amend development agreement for Shadow Ridge subdivision. Trying to get the date on the top here. July 12th, 2013. With the date on the top, but that was just whenever they hit it with the stamp. Let me, if you could give me a second to answer that, sir. That would be appreciated.
yes, sir.
Kit Shy.
Sorry.
I read the ordinance, and the ordinance essentially directed the developer to prepare a plat that amended the zoning and the setbacks. And that's what was recorded at the county, was the plat in 2006. It was supposed to be in compliance with the ordinance. Now, there's other things in the ordinance as well that had to do with the sidewalks. And those are also on that amended plat. The sidewalks are mentioned as being removed from the responsibility of the developer. The ordinance, as I read it, was to direct the developer to create a plat to accomplish the items that they had approved at the meeting.
Okay.
That's my understanding of it.
Kit, where did you read this ordinance?
It was in some of the paperwork that I got. We've been doing this for a couple of weeks now, back and forth. But the ordinance was recorded
Where?
at the county. And all the documents are usually recorded at the county because that's how the title company picks them up to make sure that, I mean, you don't record deeds here. You know, the deeds to the property are recorded at the county, so there's a little confusion in that.
The deeds, state the zoning in the deed. Oh, the deed is really based on the land, correct? It doesn't say what it's commercial or
In my
residential.
experience, I've never seen a title commitment to guarantee zoning.
Nor have I.
I'm trying to find out what it is.
I might have it here.
Is that more of like covenants or CCR? The general feeling of the community, otherwise known as the values of that community. Reading through that, it looks like that's what the community wants. And I felt like I could fit in, or that could fit. And do you all have the current CCRs right now with you? The current CCR?
I don't know that we're discussing the CCR itself, so it's not really the town. We don't have a claim over the CCR. We can choose to, I guess, respect it, but it's not.
Right. But it's not something we enforce. While we're looking for
But it
this,
seems like the CCRs are the wishes for the multifamily units. And hold on one second for the interpreter. I would like to ask the commission that they consider the CCR's desires for multifamily units. You may have different information. It seems that you do believe that it has been rezoned to single family units. And if that's the case, I would like to ask officially that you respect or regard the unit, wishes of CCR values.
I will say that me personally, I have the opposite information. I got great majority of letters to me opposing, not in favor of multifamily. But we are going to hear from the residents of the area as well. So I would agree that if the development internally would choose to want it, then I don't think any of us would oppose it. I think the main thing, the information we have, is the greater majority opposes.
At the beginning, I'm not sure if it was Caleb who stated it or if the applicant, but it was stated that there was an intent in the area of, and I take that to mean Shadow Ridge, to change to multifamily. I see that.
I haven't seen that. Is that correct, or do you have any?
Could you repeat the question? I
In the,
apologize.
I think it was when you were talking about the applicant, or maybe it was when the applicant was talking about it, made a statement that the change to multifamily was in accordance, in line with the direction of which the housing development was gonna go, or the direction of the community. And
Well, during the Shadow Ridge meetings,
I don't think
maybe.
that's been established.
Yeah, during the Shadow Ridge meetings, maybe. I have here the declaration of 2005 showing that it was single family, and then the amendment at 2006 showing multifamily. We're still looking for the ordinance as of this time right now. Yeah, I'm still looking for the actual ordinance. And I might not have it in this document. I could just be looking over it though.
Well, I think at this point, if we could hear from the opposed. Anybody?
I would like to just
Well,
speak one thing
Okay, I am asking for a representative for the whole group.
right here.
Just.
Please ask the state.
And yes. Could I have you state your name and address, sir?
My name is Ron Frobel, 30 Loomis Ford, lots 8, 9, 10, and 11. You're directly across from 12 and 13. We were told about this because we were within 200 feet of a proposed zoning change.
Yes.
In fact, everyone here is within 200 feet. In other words, the whole subdivision is affected by this. Not just us, because if there's a rezoning, that sets precedent for other lots or singles, multiple lots to be rezoned multifamily, or commercial.
And there are lots in the area that are already commercial, are there not?
1 through 6.
6, okay.
So 1 through 6 are commercial, the rest are single family development.
Okay.
Zone single family. So it really affects all the properties within the Shadow Ridge section. The application by PACCT Investments, we found is not acceptable. When we went out to everybody in the subdivision, we actually had a homeowners meeting on the 24th of May. And I think we probably had 95% of the residents that are here, not including people that are out of state, attend that meeting. And no one wants a rezoning to multifamily. This is not just multifamily, it's commercial. It's 12 apartment buildings, 12 apartment units, 6 in each building, if I'm not mistaken. This is commercial. It's not just a duplex. Okay, we don't want commercial properties within Shadow Ridge at all. None of us. The proposed zoning change itself is directly against the low-density, single-family housing. This brings in high-density housing, apartment complexes. And that can change to larger apartment complexes in the future if this zoning goes through, rezone. 12 and 13 are the smallest lots within the subdivision, or at least 2 of the smallest lots within the subdivision. And it contains a drainage structure, open space, very tight, no parking for 12 units. This, by the way, this summary went out to everyone, I think, on the board as well. But there's sufficient land available, within West Cliff, within the county, to develop apartment complexes, commercial structure. We don't need it in a single-family residential zone area. There's no need for a zoning change at all within the Shadow Ridge development. There's no need, it wasn't shown by the applicant at all. There's no need for apartments in there. The zoning change is not consistent with the surrounding properties. That's one of the biggest oppositions from all the residents. They're all single family, it's a quiet development. In residential or multifamily apartments, noise, traffic, you name it. It's gonna change. Property values. Any rezoning will affect the quality of life of all the residents within there, not just us across from that apartment complex, but everyone in there. Traffic, you name it. So this request for zoning change comes from an outside commercial by PACCT. It's an investment contracting company. It's for profit. You build apartment units, you get rents. It's a commercial entity. Doesn't belong in a subdivision. As far as I know, there's more than 9 lots owned by either the LLC or by individuals associated with the LLC. So it's going, as far as I know, there's at least 13. The character of the Shadow Ridge community would be changed forever if it's allowed to have apartment complexes of commercial buildings placed within the subdivision itself. And it should not be allowed. And I think I speak on behalf of everyone that's in Shadow Rift. And believe me, I think everyone is on board with this.
I'm sorry, go ahead, please, I'm sorry.
That's pretty much sums it up. I mean, that's.
Do you have a signed petition or
Yes.
letters or anything?
Yes, we have a signed petition. How many signatures on there now?
There are 60 people who have signed the petition or signed an email saying they're opposed.
We have at least 60 signed
Can
in
you
the
say-
petition against this.
Can you say what percentage that represents? The 60 people, what
Well,
percentage
it's
of?
not only, this is just the property owners that were here within the subdivision and lot owners that are outside the sub, that are out
I'd
of
like to make
state.
that
Well,
distinction.
there's what? We have how many lots? 107, is it?
Yes.
Yeah, 107 will probably have at least 70%, 80% at least.
Just to be clear, we received some letters from people that were in favor of the change. Wasn't as many, but they do exist.
That would be for a developer that probably wants to put in an apartment complex or larger units.
And I didn't do the research on that, but.
Oh, yes, just one other, you mentioned they don't, it's commercial, and it is commercial, but it's also residential. But the 1 through 6 is zone commercial.
Right.
Those be changed to, multifamily,
1 through 6?
zone commercial.
It's zone commercial, so apartments can go in there. There's a whole string of allowed commercial.
Would you be okay with that?
Yeah. I wouldn't have a problem with it.
30 feet away from where you are?
I have no problem. We have a barn that was built right next to us. Why would I be concerned about an apartment
That's a
complex in
violation of the
commercial?
CCR.
No, it's not a violation. Because 1 through 6 is commercial.
Well, that's a separate issue.
It is, we're not
We're not here
We're not arguing the CCR.
to talk about that issue. I would not be in favor of apartments on those commercial properties, personally.
And I don't, as I understand it, the state doesn't regard apartment complexes or living complexes as commercial. And they do have the authority on that.
I believe it's over 4 or 5 units. Over that is commercial.
No, it goes under commercial code for building code, but the town can rezone it multifamily, the residential multifamily if they want.
And Clay, can I get your input on that statement?
Yeah, sure, go ahead. I'm sorry, I'm trying to also communicate with staff while we're doing this, so it's a little difficult, but that's okay. What was the question?
At what stage or if basically living quarters or apartments, et cetera, where do we draw the line regarding it being considered a commercial enterprise or not?
Well, I mean, taken to its logical extreme, basically, development of single-family residences can still be considered commercial. If you're the developer, then it's commercial. You're trying to develop single-family residences to sell and make money. So I think what's happening here is we're kind of mixing and matching our own definitions without, clear understanding of what we're talking about. Just because it's a commercial venture has nothing to do, or if it's a possible commercial venture, has nothing to do with its underlying, zoning. The request is for multifamily, and there's 2 options you guys have. If you don't think you have enough information, you can pause the application and ask the applicant to supplement with the information necessary. I think discussion around the CCRs and enforcement of you know, whatever might or might not be in county records is not only moot, but it's beyond the authority of the planning commission or even the town BOT to decide. We can't change county records. All we can do is file them appropriately when we do our plats, et cetera. And we can't intervene or otherwise enforce private party CCRs. So the only determination before the board now, or before the commission, excuse me, is do you think it's appropriate to rezone it to multifamily? And Caleb has already aptly outlined the instances which you could consider a rezone. And so you need to either decide based on only the evidence that you have in front of you. And if you think that the applicant needs to supplement something, you can send the applicant back to supplement it. Or if you think you have enough information, you can make a decision now regarding the zoning and put your decision to the BOT for final determination. I'm unaware of anything else that you would need to do. Go ahead, Caleb.
Thank you, apologize. I do want to just state for the record, on the second day of July 2013, this is through the town of Westcliff. This letter says on section H, according to the town's records, the Board of Trustees never subsequently took formal action to execute an amendment to the development agreement or to approve the filing and recording of the amended plat by Shadow Ridge in October 2006. So they never took any formal action on an ordinance for that, but I have here the recorded amendment for that plat on Shadow Ridge does clearly state lots 7 through 109 inclusive single family. Now, what could have happened is that the Board of Trustees never formally took any action to pass it into an ordinance to change it from single family to multifamily. And the town of Westcliff just got a plat map from the developer themselves, from Shy Surveyors, showing from lot 7 through 109. Yeah, go ahead and one. As here 7 through 109 inclusive single family, but here they never took any formal action to approve the filing and reporting of the amended plat by Shadow Ridge in October 2006.
Okay, and in 2013, when that statement was recorded, there was no action in and around with that?
Goodness gracious, so much paragraphs. Okay, I do see an accepted and agreed to from the town of Westcliff, and Jerry Cyber of Shadow Ridge Holdings. But they did go back, the town, so they did it in 2006 and they came back in 2003. The town agrees at its expense to take formal action, maybe required by the Board of Trustees. Slow down.
Can you slow down now?
Okay.
They did what?
So I see here that the town did sign and accepted and agreed to with the current mayor of that time, Christy Veltri, and the owner of Shadow Ridge Holdings LLC. It says here, the last point, number 6, the town agrees at its expense to take whatever formal action may be required by the Board of Trustees to adopt this agreement and to approve the amended plat filed by Shadow Ridge in October 2006. Shadow Ridge agrees at its expense to record this agreement in the county records. Once the agreement is formally approved and adopted by the town, provide a copy of the stamped reported agreement to the town. So I guess they went back all the way in at 2006, it was amended by Shadow Ridge to change these from single family to multifamily, but no formal board action was taken until 2000. Hold on, please don't interrupt. Until 2013, but there still is no ordinance.
I think you got that backwards.
Yeah.
Sorry.
You said in 2006, you said from single family to multifamily.
Oh, yes, in 2006, they changed it from multifamily to single family, not as in Shadow Ridge, but it was never, there was no formal action on the town. So they went back in 2013 and basically said what I just said in number 6 was was to take formal action on that. But there's, I can't find an ordinance in this document, but it does relate on the Shadow Ridge plat, so, and Mr. Oshman's defense, you know, there is some inconsistencies with that, and until we find the ordinance itself.
Right, so it sounds like there was an agreement to make an ordinance, then there was another agreement to make an ordinance, and then
Did they follow
we
through?
don't know at this point.
And that's why it's kind of a conundrum.
Get shy, please.
Just, it's a little difficult for me to understand. The mayor signed the plat.
Yeah, I agree.
Planning Commission chairman signed the plat.
But we don't-
That's not a formal action to accomplish what's on the plat?
I think we still need to have that change.
Into an ordinance.
Am I incorrect?
Like,
Yeah, I mean, you guys, it sounds to me like we have some pretty major issues that need to be ironed out here. You know, Caleb, for me, and for the purposes of this commission hearing, I think the bottom line, and correct me if I'm wrong, is that currently it's zoned as single-family residential, correct? For the town.
that's what I would consider it zoning, correct?
But there are agreements out there that took place arguably a decade ago that at least contemplate a multifamily use. Is that correct?
No, I think we got that backwards.
No, so if I can clarify, it was switched from multifamily to single family 2006, but never passed into a motion on 2006. Then in 2013, the town said they would take formal action to adopt this agreement, stating that it would be moved from multifamily to single family, but there is no ordinance on that. That is what I'm saying.
But it did actually happen.
It did actually happen on the plat on the 10th day of October 2006, signed by I can't really read this. The chair, Jess Price, thank you. The chairman, Kathy Reese, town clerk.
So we're back to where we started. These are single family residential. The commission just needs to decide whether or not to accept the zoning application to change it back to multifamily.
Yes, and thank you. I apologize. I really wanted just to clear the history behind this, but get the facts straight.
Right. Now, I don't understand this claim, but is there a possibility that Seifert wouldn't have needed an ordinance at the time? Since he had 67%, or is that even applicable? I mean, I don't know that that would land today, but a decade ago or nearly 2 decades ago.
Yeah, again, as a zoning official, when I look at the minute, and again, I didn't want to confuse anybody, but I had to bring some clarity to the subject of everything. As a zoning official, if I'm looking on the Shadow Ridge PUD map, and it clearly does state lot 7 through 109 inclusive single family. So again, sorry, Clay, like you are right, we are back to the decision on whether to accept it.
I've got two questions. When we take this to the county, is the plat the only thing we take, or do we take the documentation that backs that up in terms of the change?
They took that, Seifert did, to have that recorded, not the town. And no, we did not have that documentation because all we had was the plat.
Ask whether or not we as a town, when we take it to the county, the plat, to have it recorded as changed, whether there was other documentation that, you know, ordinances that went with it. The clerk just told me that Jerry Seifert, the owner of 7% of the subdivision, took the plat to the county himself to have it recorded. So I have another question of the applicant. Did you purchase this property before or after you heard from the trustee? I'm sorry.
question to Mr. Alford.
Yes.
Okay.
Did you purchase the property before or after you heard from the title company?
Before.
So you purchased it before you talked to the title company, and then you found out.
I'm not sure I understand the question. Say it one more time.
Did you purchase the property before you talked to the title company or after you talked?
So I collected information that affected my decision to buy, to decide which lot to purchase. So obviously I spoke to the title company or I made the purchase and I was under the understanding that it was a multifamily property.
So, interpreter, was it that he say he purchased this after he heard from the title company?
Correct.
Okay.
Chris,
Oh, after.
Yes.
if I may, I think we should, so again, I wanted to clear that up. As a zoning official, I see here on the map, lot 7 through 109, inclusive or single family. I think it should, we should go back around and just, do we approve this or do we not? So that's what I would.
I still would like to hear from the side that is in favor, the residents that are in favor. But my guess is, I think ultimately what I would like to see is more documentation from the applicant. And if we have any other documentation that the town might have that would clarify it any better too. So,
May I say something?
yes, ma'am.
My name is Eva Bindor. And I'm just wondering if it would be the commission's recommendation to go against all of these property owners. We all bought with the understanding that these are single family lots. And if this comes down to basically a clerical error between the town and the county, I don't feel that the existing residents should be responsible, to take on the responsibility for that, because we don't want a multifamily unit in our neighborhood. It should not be our obligation to go along with this.
I understand, but I think the town has an obligation as well to what was legally established.
Yeah, but
I'm not,
all of our lots we were legally told that these were all single family. When we bought the properties, we were told this is a single family, this is well established.
Legally, if it was never legally established, I'm not sure we know that answer at this point. That's what we're trying to
Right,
clarify
right.
here. We're not taking sides at this point.
No,
We're
no.
trying to understand what is this bigger picture. Applicant, please.
But
I just wanted to add something just for clarity. And I know that people are afraid of where I'm coming from. I prefer not to use the word developer. I'd like to move away from that. I am a property owner and a home builder, and I am in support of the town's needs. I do own 9 lots. They are technically very small, and I have 2 personal lots within the community that are very close to 12 and 13, and I intend to build those as my primary residence. I love this town and I come here a lot. It's a beautiful place. And I think that it's been misconceived with the amount of traffic or the change to the neighbors that it would bring. The intent is not to rezone the other 7 lots. That's not going to happen. From my understanding, before I bought the property, they were not multifamily, only 12 and 13 were. So those are the 2 that are in consideration. And the others, I have different potentials. I might sell them to another owner. I might build a suite. I haven't decided yet. But to call me an outsider, that's trying to disrupt the community is not true. I'm foundationally based and the information that I bring is foundationally based and it is for the well-being of West Cliff community, not just, I think that it's important to hear everyone's perspective and I don't want to disregard that. I think that West Cliff does need more housing and I think it could be beneficial to the issues that we currently face. The numbers in growth that's already here, it's already happening. And there are people that are trying to come up with creative wins or creative win-win situations. So 1 through 6, I've seen what they can do with that. There's lots and lots of options. And my hope is that we can change those to multifamily units, 1 through 6, and not other units, other lots. And I think that there's an auto shop, there's also different types of uses being used through 1 through 6. And hold on 1 second, interpreter. The nature of our location west of the entrance is interesting because as you drive through there, you can see the storage center, this disposal business. And I think to myself, this place would be better used if there was single housing, multifamily housing, but they're already there. At the same time, our community has those businesses as you enter. So I understand the trade-off where you see the storage facility right there. I know you guys drive by it every day. And there is larger land in town. And I think that with the discussion of the views, like obstruction of views from the mountain, I don't think that's also an argument because I've done the elevation math and the elevation is differing in different areas, and my plans would not disrupt Mr. Wolf's complaint saying that it would obstruct his view because he is actually higher.
Excuse me, I'm Mr. Wolf. I never said it would obstruct my view. I said it would obstruct the view of other residents of Shadow Bridge.
Oh, I appreciate that. Thank you for the clarification. I agree with you. In my assessment, mostly the homeowners nearest the edge have obstructed views. So my recommendation or my application would sort of have very minimal impact on what's already there. Just that fear of obstructing the view doesn't seem like a potential for what I plan to build.
I have another comment from a member, if I may.
Can you speak up louder?
I'm Rose.
Okay.
I live directly across the street from where 12 and 13 sits, where the proposed, 3-story apartment building. So I'm heavily impacted by all of the traffic, the noise, the parking, everything. Dark skies. I love sitting out in my yard and looking at the dark skies. I built a little platform. I won't be able to do that because light is going to come in. It's just not feasible. I would be really, really stressed. Not because I have something against him personally, just I would be stressed. I would have to move. And several other residents I've spoken to have the same opinion. They would have to move. Because when we bought there, it was single family. There was never an issue about apartments going right in across the street.
I understand. I think, though, that we still have to figure out somebody was misled, is what it sounds like, whether it was the applicant or the rest of the residents. We don't know that at this point. I think that's where we're gonna really need to go, is we're gonna want more documentation from the applicant, showing the title information that it claims to be multifamily, any other documentations you might have that would show that's the case.
I'm willing to modify as well to fit in with, like where it says the 12 parking spaces, because that's apparently what the lot, dimensions, seem to allow. But I would be, there's a higher potential for, from what I understand from the city, is that could be reduced to 6.
One car per lot.
6 cars per. If it were up to me, there would be no parking required because we live in town limitations. And there's a lot of people who want that healthy lifestyle, who want to bike to where they want to get to. Everything's in walking distance. And also working.
Is to the issue at hand, is for the town.
Right now, it sounds like the issue is a little bit of thinking that perhaps the applicant was misled because of potential clerical errors. You also have to weigh into the concept that 60 other applicants or 60 other people who own homes over there would have been misled the opposite way. So there's a really big scale difference here.
Yes. One way or another, we've got, I see you, ma'am. Hold on.
Okay, so,
Hold on, ma'am. One way or another, we've got some mopping up to take care of. So, okay.
okay, so I'm Nancy Viking, misled is a good word. The covenants were there. We wanted single family. We did not want the apartments coming in. And if you have a breach of a covenant, the parties involved in that contract and they fail to comply with that promises made in that agreement, in simple words, a covenant is a written promise that cannot be violated. And in our particular covenant, it was perpetuity. That's a law that says that covenant was going to stay into its state. The time that I lived there, my survivors lived there, people that are coming in and inheriting my house. And if it's going down in value, I'm losing value for my family. The defaulting parties have breached the covenant and they're liable to, you know, it's not right that they can breach a covenant that we have. It might not be.
We have no authority over your covenants. So.
Yeah.
The gentleman on the end here.
Just a quick minute. I think I can write.
Your name, please?
Thank you.
Thank you.
Jonathan Caesar. I'm the first commercial property in that lot, so I just want to provide a few comments. First, I am a little sympathetic to the discrepancy because that happened to us as well. The CCNRs and all that were given to us, there was and we had material delivered. And so what did we do? Right, we rolled up the sleeves and went to every community member, those that weren't, right, we mailed letters to request permission to do what we wanted to do that was not in agreement with the newly discovered covenant. We got 67% to say, we're good with that. Now, in the spirit of because we were tracking, it was a single family community, right? Yeah, there were 6 commercial lots, but those are bound in terms of what they can be built in there. We ensured we were in compliance with that. But knowing that we were commercial, we wanted to ensure we met the spirit and the intent of the community. So as we're building it as, you know, marching towards that single family multi-use, right? Single family residence on top, or commercial, space down below. So like I said, I just wanted to provide, I said, mistakes happen, things don't get recorded, realtors don't provide all the material, escrow companies don't, right? There's mistakes that do happen. However, I think, just as was mentioned, right, I think it's imperative to look at core intent and the vision of what that community was pushing towards, and I think we have that record dating back to 2006.
Yeah, I think we kind of save this for next month, give time for Mr. Oshman to get his paperwork from the title company that states whether there's multifamily or not, and give the town some time to find the
Any other
ordinance.
documentation that supports that.
And in town for town staff to find the ordinance.
So, my name is Mark Mittendorf. I would just like to briefly mention 2 or 3 concerns that haven't been brought up yet. And I think, I don't want to say I'm speaking for the whole community, but these are my concerns. And one is that the chances are this effort will lower our property values. The city of Westcliff just went through an exercise last year to raise our property taxes. And we had to push back on that. But yet they were still raised. The subdivision has been on a moratorium for sewer and water taps because of issues with the water. Let me finish, please. With the water system. 12 additional units, and we really don't know how many more are going to just put a further load on that system. And third, no one has spoken to whether or not this is low income, intended for low income. We have no assurance that it's not going to be low income. And I hate to be that kind of person, not in my backyard, but we have zoned single family zoning in place. And there's no good reason to change that.
Well, we're trying to determine right now if you really even have it in place. I'm not saying, but was the DOT ever made that
Caleb,
change?
do you consider this a legal document?
I'm not, look, I answered right facts from, that's all I've been doing is stating facts, okay? So before I answer anything else, I would request and recommend to the planning commission that we give time for the correct documentation to be put forward, to look for any inconsistencies, and that we push this motion or push this agenda to next month. That would be my recommendation.
Motion that we table this till next month's meeting. In the meantime, we will let the. I make a motion that we table this to next month's meeting. We will ask the applicant. We'll do this in writing, what you need to provide us. And internally, we will look for documentations that what was supposed to happen. So we will do that. We will do that research internally. That's my motion.
I second.
In the discussion,
So a motion has been made and seconded as stated.
motion has been made and seconded as stated.
It's all happening so fast.
Yay, all in favor, say aye. Aye. No. Let me just add one further thing, please. It's our job as this board to try and everybody, hear everybody. Hear the residents and your concerns. I have written back to a number of people who have written you as mayor. And we are trying to just do our duty of due diligence on this whole matter. So we understand your concerns.
We understand your concerns. Obviously, there's a hiccup someplace in the process that happened 20 years ago. We're gonna try to figure that out. Thank you, Mr. Mayor. Meeting adjourned?
Need a motion
Oh,
first and second?
I'll make a motion to adjourn.
Second. All those in favor? Aye.
Aye.
Did we just adjourn?
Yeah.
Lawyer, spell it out.